probably a little while, we're going to have our feature for Trusting Tuesday, and that is going to be our case of the week. I got a couple doozies, and I wish I could just kind of spout off every day and say, here's what I did last week with all of my clients. Here's what I did last week, because I just have a lot of fun dealing with clients and their personal issues and all that kind of thing, but it's personal. So I can't just spout off about how that all works. However, I will be talking about some of those when we do our case of the week. All right. Today's Tax Tuesday, Trusting Tuesday. We talk about wills and trusts all day long, all the way to the top of the hour. I'd love to encourage your participation. If you want to have a question answered on air, I'd be happy to answer that. And you just have to call in to 888-344-1170, and Noah will patch you through to me so that you can ask me a question, and I'll be happy to answer that on the air. And don't worry if you think you're going to stump me. If you do, that's, congratulations. But we'll just figure out a way to answer your question the best we can. And tomorrow we are going to have Ken Pecos. You remember Ken? He's our financial wizard for real estate. Okay, how to buy and sell real estate, whether it's commercial property, whether it's for rental or personal residence, don't matter. Ken knows how to do it. He's got the goods, he's got the information, he's got the smarts. That's Ken Pecos tomorrow. And on Thursday, we have Anthony Wright, our financial mastermind. I was meeting with a client today, and they said, so who do I need to talk to about my financial situation? Because I was talking to him about his particular estate planning situation. And I said, well, I would. And he says, don't you have a guy on your radio show? I said, that's what I was going to say. Anthony Wright, 931 retired. And I wrote it down, slid him the note across. He said, awesome. I'll go talk to Anthony. So I'm going to talk to Anthony about that on Thursday to get his question answered live on the air. All right. To be part of the show again, it's 888-344-1170. I promised yesterday in finishing up the show that I was going to move forward. We're talking about training people like the successor trustees, how to take care of their family trust. I am endlessly concerned with how successor trustees are doing or not doing their job. It all stems from the fact that if you do agree to serve as a successor trustee, and you step into that role, you are a fiduciary. You're acting in a fiduciary capacity. That means that whether you're professional or not, whether you agree to be paid or not, whether the trust says to pay or not, it doesn't matter. If you step into those shoes, you have a duty to act according to the California Probate Code, which you don't even know. So you are held to a standard that you don't know. Therefore, it is so important on you to then find somebody that can help you do your job. I mean, surfing for videos on YouTube, good luck with that. We do it all the time. But, it's like with anything, you look at a video and go, oh, that's really great. You look at another one and go, oh, whoa, wait, I thought, okay. You look at another one and go, oh, my goodness. So, I mean, I do have videos on my website, gqlaw.com, and on my YouTube website, which the YouTube channel is, you just go to Gary Quackenbush, or you can go to GQ space LAW and just look up on YouTube. And I have a whole library of our radio shows and videos and training videos. So you can learn that way, but then you're still doing it yourself. And as a successor trustee, you're obligated under California law to delegate duties that you cannot do professionally. You can't be a lawyer for your family's trust. You can be a lawyer for yourself. You can be a lawyer for your children, but you can't be a lawyer for anybody else. And as a fiduciary, you cannot be a lawyer, which means when it requires you to record a deed or to file a document or prepare a document or provide any information or advice, that is legal stuff. Now, I know as an individual, you think in terms of, well, Gary, I do that all the time. I do my own tax returns. I draft up rental agreements for my tenants. I have a contract with my brother. I can download forms and fill them all out. Good. Awesome. Congratulations. That's wonderful. And I'm glad you understand that stuff. But if you're going to do it in a capacity as a fiduciary, or if you're going to get paid to do it, you have to have a license. And if you're going to do it in California, it has to be a law license in California, or else it is illegal. Okay. Who's going to stop you? Oh, just the beneficiaries. You know, if you do something wrong and you're practicing law without a license, that's a bad thing. That could get you kicked out as a successor trustee, fined, or surcharged. There's just too many things to think about. And why do you need the headache? You're going to be the successor trustee. Take it from me, it's a pain in the neck. It's difficult work. I get paid a lot of money to help people do it. Other firms get paid even more, but it's a lot of work. That's why it costs money. Now, don't act as a lawyer for your family trust if you're the successor trustee. Do not prepare the tax returns for your family trust if you are the successor trustee, unless you are a licensed tax professional. Because again, you can prepare your own tax returns. You can prepare tax returns for your dad while he's alive. You can prepare it for your kids. You can do whatever you want with family members that are not paying you. You can do whatever you want. Plus, they're not going to sue you, right? However, if you are a successor trustee, you now have the fiduciary obligation to do it right. Do not prepare the return. I don't even care if you know how. I really don't care if you know how. Don't do it yourself. Hire a tax professional. Let them figure it out. Besides, it's a 1041. Do you do 1041s? Probably not. Do you do 706s? Well, if you do, and you do know how to do them, and you're not a tax professional, you're in the wrong industry. And you need to become a tax professional, because 706s are very difficult. You shouldn't be trying them yourself. You will be providing for the tax professional and for the lawyer. You'll be providing them all the information they ask for. And it's going to be more than you normally would provide to your regular tax professional. You're going to be providing them all kinds of information to get an accounting and do the tax returns and do the legal work and stuff like that. So don't worry, you'll have your hands full. Just don't act in the place of a professional with a license to do what they're supposed to do. As a successor trustee, you are one thing. That is, you're a quarterback. You're a quarterback to manage the entire estate trust affairs stuff. You're the quarterback. You're not the tight end, the receiver, the center, all that stuff all at the same time. You're not the whole team. You're the quarterback. You're calling the shots with advice and with counsel. That's what you're supposed to do as a successor trustee. 888-344-1170 is the number to talk to me and ask me a question. Coming up next, I want to talk about specifically, what is this accounting thing? What is that with estate planning? We're talking about that right now on the Word of Wealth.
You've got questions.
Case of the week here.
Unwell.
Yeah.
With Gary Quackenbush of GQ Law. Gary's
All right.
view peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time, and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, our listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people, because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there, filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQlaw.com, 855-500-TRUST, GQlaw.com.
Who will you trust with the biggest financial decision of your lifetime? If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group. From single-family attached homes to luxury high-value waterfront properties to apartment buildings, Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com, or call 619-977-8419.
DRE number 010566969, brokered by eXp Realty.
It's not unusual to use our heat and the AC.
Outreach, The Word on Wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQ Law.
Live.
Right. I wanted to case of the week. So we've got
That's why you need to be told that it's the Gary Quackenbush GQ Law case of the week.
thank you, Noah. Noah is our inspired background voice man. And yeah, so thank you, Noah, for that. So the case
I'm
of
gonna
the
go back in my box now.
week, back in your box. Two different cases of the week. Number one, this was kind of crazy. So this one, the dad decided that he hated lawyers and he didn't, that he could take care of things himself. And he decided, I don't need a trust. All I have is a house and I am going to bypass any lawyer stuff. And he created a deed. He had a friend of his, a lawyer, conveniently, put together a deed. And the deed said that the house went from dad to dad and his 6 kids. So the title was originally Mama died. So now it became dad's. And then dad puts on the title that he transfers it to himself and 1, 2, 3, 4, 5, 6 children. Okay. He wanted to avoid probate, wanted to avoid attorneys, thought he was doing the right thing, and he died. I got a call from one of the kids and saying, hey, Gary, I want you to help us out. So my dad died. Here's the deed to the house. And I looked at it, and sure enough, it was dad and 6 kids. So dad had died, so that's easy. You can do an affidavit of death of joint tenant, and that makes it so that he is no longer the owner of the property, but 6 kids owned it. So did the 6 kids want to continue owning the house now, all 6 children at the same time? And they said no, because they lived in 5 different states. They weren't interested in having it as a rental. It wasn't that great of a rental. And besides, divided by 6 people, it would just be more of a hassle than it was worth. So they decided that they wanted to have the property sold. In order to do that, we had to get the property transferred all in one place. Or we could have had all 6 kids sign the escrow, all 6 kids sign all the documents. And sure, we could have done it with DocuSign and all that kind of thing, but all 6 kids' names are on everything, including the deed to the house. And what they decided to do was to transfer it all to one of their siblings and have him sell it on the promise that he would then distribute the money to all 6. And that was the plan. So after we got started putting together the deed to transfer it from the 5 of the kids to the 1 kid, affidavit of death of joint tenant with dad, his notice of death. And then we did these notices in all 5 other states. And what we ran into is that each of the states had a different requirement for a deed. Some of the issues were the notary seal, and the notary in some states was not just a notary; that had to have a jurat, and other states they had to have some other funky thing going on, and the deeds weren't right. But they couldn't do it in that state because it required a jurat and it had to have different language and all that. So bottom line is, believe it or not, and we worked hard. It took us 9 months. 9 months later, we got the deed all sorted out. Part of it was some of the kids just weren't available. They traveled a lot. They weren't sure what they're going to do. We're having to explain what's going on. And I know you guys, you're going to give it to your brother so they can sell it. And that was scary for them. Like, well, if I give it to my brother, what if he files bankruptcy? He said, well, then your house goes into bankruptcy. So you're right. And what if my brother doesn't insure it? And so there's a lot of issues with the co-ownership. And when you're trying to sell it, having all 6 people sign it when they're in 5 different states. So they decided, and they understood the risk. It was all being transferred to the 1 brother. And that took us months to pull off because some of the kids didn't want to do it. They were being told not to do it. They were being told they're going to lose their estate. So I had to explain what all of your options were. So bad idea. Sorry, Dad. You did leave a house to the kids. It was worth a lot of money. They each got, $150,000 or something. Can't remember the exact number, but anyway, should have done a trust. If you did a trust, you would have had one of your kids being successor trustee. That kid would have sold the house and divided the proceeds, all 6 kids. If all 6 kids wanted to keep the house, then they could have transferred it from the trust signed by one person, the successor trustee, who could have then signed the deed to all 6 kids. So a trust, bad idea to try to avoid things. You ended up costing way more money than it would have if you had just done a trust, which, they're easy to do. We whip them out all the time. And by the way, if you want me to help you with that, it's 855-500-TRUST. So I can do your trust. I can help you out. Don't try to put your house into deed it into the names of your children. And I don't know, there's so many problems with that. I mean, what if one of the kids filed bankruptcy? What if one of the kids had a debt problem? What if one of the kids had a family court issue again, order against him? What if one of the kids got into a car accident and didn't have any car insurance, and now your home that is now co-owned with 6 of your children is now part of a lawsuit for collections on an uninsured or underinsured motorist? So don't put your kids on property. It's just not a good idea. It's not very insightful or forward-looking. Put it in a trust. That is insightful and forward-looking. Okay, that's case 1. Case 2. So sometimes your attorney retires or doesn't practice law anymore for whatever reason, and that happens. And I've reviewed several trusts lately where the attorney doesn't practice law anymore. He can't. And so there were questions of the trust, and it's an older trust. Is this going to work? And I'm going through some of the questions and all that. And the thing that I've been finding is the trusts nowadays, some of the trusts that I'm seeing are totally ignoring the fact that the law changed. Okay. What I am finding is that there are companies that want everybody to own an 11-bedroom home. Okay. That's just what you should have. Okay? Everybody should have a 10-bedroom home. Yeah. It doesn't matter if you're married, you should have a 10-bedroom home. If you have 4 kids, should have a 10-bedroom home. If you have 8 kids, you should have a 10-bedroom home. If you have 1 kid, you should have a 10-bedroom home. It's just crazy. So I'm seeing these trusts that are so complicated and so messed up that they're requiring that on the first death, that the surviving spouse is to determine whether they need an A and a B and a C, or an A and a B, or a B and a C. I mean, it's split up into 3 different ways. There's all these tests, all that stuff. Here's what happens. 90% of the time, the surviving spouse will say, I have no idea what that means. I'm not going to do anything. Forget it. Just lost my husband. He's been with me for 50 years. I'm not going to think about it. That's too messy. That lawyer I don't know what they're doing. and they ignore it. So then we don't have to deal with it until later when mom passes away. And then the kids come in and say, Gary, here's this trust. What do? We need to do, you call it trust administration, right? So I read through the trust and I go, oh, did mom 2 years ago, did she do any of the stuff that it said in the trust? And I'm reading through, did they do the AB split or the ABC split? Was anything done? No, none of that was done. Well, it worked out okay as long as mom was competent and didn't need any financial help until she died. Okay. So if she became incompetent, that would be a complete disaster, because if she doesn't do the split, which she's supposed to do on an AB or an ABC trust, she didn't do the split. She's in violation of the terms of the trust. She can fix it while she's alive, or she can pass away and it passes on to the kids. And then there's some, little forgiveness issues. But if she became incapacitated and now we tried to fix the trust, it ain't possible. Okay. Because we have a problem. We can't modify the trust without her signature. So now we're just stuck. And what I don't like, and I was talking to a client of mine this afternoon, what we don't want is stuck. I understand that there's a 30% likelihood that you won't become incapacitated before you die. There's a 30% likelihood of that. I get it. But should you be willing to gamble on that 30% chance that you will not become incapacitated with your estate plan, with all of your money? Okay, so here's what happens. We have a situation where husband and wife had a trust, all good to go, and part of the property is outside of the trust. Husband is thinking, okay, that's my retirement account. It has $500,000 in it, and it has a beneficiary, my wife. Well, he didn't check, and he became incapacitated. So we need that money now. We need that money to take care of him. And well, there is a beneficiary. It's his wife, but he's not dead. Beneficiary designations don't do squat if the person is alive and incapacitated. You can't change beneficiary designation. You can't access the account. You can't do anything. You have to get a conservator over that person. And this would be a husband. You got to get a conservatorship over your husband so you can then take his money that he earned and put away while you were married to him for the last 40 years. And you got to get a court authorized conservatorship over him to access that money to take care of him. It's insane. Better would have been to just have that account in the trust. Would have been easy, would have been simple. You have to go to the right financial advisor. If they don't know what they're doing, you get a new financial advisor, or you get an attorney that knows what they're doing and they help you do it. But if the account were in the trust, we wouldn't have had to do a conservatorship. So with your estate plan, if it's not done right, and you have this complicated ABC trust, and now the surviving spouse becomes incapacitated, now what do? You have no authority to do anything. You're stuck, and I don't like stuck. So multiple things have to happen. One, when your spouse passes away, you need to look at the trust. And if there's anything that needs to be done, like ABC or an election or a denial or a rejection or a disclaimer, do it. Don't wait until you become incapacitated and your kids figure it out. Don't wait until you pass away when your kids figure it out. Do it. So on your first death, if you lose a spouse, that's a horrible thing to have happen. You lose your friend, you lose your travel buddy, you lose your companion, you lose all that stuff. And then I'm asking you to do some legal work. You don't want to think about it. And I get it. You don't have to do it right away. Just let's talk about it, because we got to change the title so it's just the survivor, change the title so there's just one trustee, change the title so that we can deal with it in case the survivor becomes incapacitated. So we got to take care of that stuff. And you got to have the trust not super complicated. If your trust is overcomplicated and it says, I have an AB trust, if you're a married couple and it says AB, I'm going to look at your assets. And if you've got, a $2 million home and, $3 million in a retirement account, you don't need an AB trust unless you have a blended family. And if you have a blended family, then we got to talk specifics on what do you want to have happen if the wife dies first, if the husband dies first, what if they die together? That's when you do an AB trust, but not like the old fashioned AB trust where you just do an AB trust because there's a husband and wife. We don't do that anymore. That's crazy. It's just not the good way to go. Modify, simplify, don't overcomplicate things. They don't need to be overcomplicated. A lot of people are using these really complicated do all, catch all, helps everybody up to $50 million trust templates. You don't need a 10-bedroom house. Most people need a 4-bedroom house, 3-bedroom, 2-bath, 4-bedroom, 3-bath. That's what most people need. You need a 10-bedroom house, fine. But I don't want to sell you a 10-bedroom house if you only need a 4-bedroom, and that's plenty, and you're very comfortable with that. All right, call me 855-500-TRUST. Let's figure it out. Let's review your trust. Let's get your trust together. Start with the basics. If you don't have a trust, get one. 855-500-TRUST. Coming up next, what is an accounting? Let's talk about it on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST. You need. Call Gary and you are 855-500-TRUST or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com. 855-500.
You're live.
I'm alive. Happy Tuesday. It is Trusting Tuesday. No, I do the announcement. Is it Trusting Tuesday or not?
It's Trusting Tuesday here on the Word on Wealth.
That is so mellow.
And Gary, you're not alone.
I am not alone. I trust in Tuesday. Trusting Tuesday. Happy Trusting Tuesday, everybody. Why is my microphone doing weird stuff? I can't hear myself talk. There we go. All right. Trusting Tuesday. There we go. Now I hear me. Oh, if you are not watching that, well, if you want to go over this stuff again, we're doing our little lesson today on trust accountings. And if you want to hear it again, make sure you go to our podcast, any podcast platform, whether it's the iTunes or the Google Podcasts or Spotify. There's a bunch of other ones. You just look for the Word on Wealth with Gary Quackenbush. Easy. There's only like 2 Word on Wealth, and one is like back in some other nation, and the other one's here. The Word on Wealth. And just find the one that you're hearing today. And you can go and review how to be a successor trustee. Even easier, call me, 855-500-TRUST. I'll teach you. Personal appointment, no problem. All right. So we talked about ABC trust being trusts are too complicated. It is not that difficult to get it right if you have a professional doing it the right way. Accountings. All right. Here's the thing that happens. Let's say, for example, is mom and dad died. You got through the funeral, got through all that stuff. It's now been a month. It's been 2 months. It's been 3 months. It's been 4 months. It's been 5 months. At the funeral, nobody wanted to talk about money because that's just kind of like taboo. And then the after party, or the celebration of life and the after time sitting around, you don't want to talk about money because that's taboo and people get really upset. Some people want to get right into it. I've been to funerals where somebody's like, immediately, okay, we want to know what to do next. It's like, take a breath. Let's deal with the funeral and then let's talk about it. And some people are, the in-laws jump in and they want to say, well, my wife wants to, whatever you want to know, don't ask yet. So that's fine. It's a little early, a little premature. I always say, wait a week or two, kind of get things settled. The main things you've got to have time to mourn and think about dad or mom's passing. And you got to go through that. And I'm not trying to be cold or calculated. I'm just trying to be realistic, because so many times the anniversary, a lot of people call it the angel day, right? So on your parents' angel day, something happens with your brain and your body. And at about the year mark, all of a sudden you start thinking about your parents dying again. And you start thinking of what happened at the funeral and how you felt and the emotions that went through your mind or didn't, and how you felt about emotions going through your mind or not. Okay. And reconciling, with that over the last year or so. And what I have found is about annually, almost everybody has this, I don't know, emotional hemorrhage. Like they all of a sudden, if we're in the middle of a trust administration, we're trying to help get the trust and stuff done. If it's at the year mark, they'll just go silent. We won't be able to get emails or calls back for a couple of months because it just happens. Okay. So, and that's not a problem. That's just normal. But if you get to that point and you go, wait a minute, I haven't heard from my sister about dad's trust money. I mean, I haven't gotten anything either. I'm a little concerned. Well, yeah, be concerned, be alarmed. Because if you believe that you're, supposed to be listed in your parents' estate plan, and if you're a child, the answer is, oh, heck yeah, you should be listed in your parents' estate plan. You're either disinherited or you're not. But whether you're in there, written out of there, disinherited, you get it all, you get none, it doesn't matter. The law requires your successor trustee sibling, whoever's the successor trustee, the law requires that they send the copy of the terms of the trust to all the beneficiaries and or the family. So it's going to be, if there's 3 kids, it has to go to 3 kids. If one kid gets it all, everybody gets to know that one kid gets it all. I have seen way too many times, believe me, where a successor trustee says, well, it all goes to me. So why do I have to tell my brother and sister? I mean, it goes to me. It says right here, the trust says right here, it all goes to me. And if it's actually true, fine. However, the law requires that the siblings, which is the kids of the mom and dad that have deceased, they get to see what the trust says. And you got to get it done sooner rather than later. Because if you don't give them the opportunity to challenge the trust, then they can challenge it for a very, very long time. So you got to get it. You got to face the music. You got to just get this thing done. Give them a copy of the terms of the trust. Give them a copy of the trust. You have to send a notification with the specific language from the California Probate Code. If you don't do that, then their right to object to the trust goes on and on and on, and it could be years from now. So you want to get that done. You want to get it up front. You want to resolve it. You want to deal with it. If somebody's going to fight about it, get it done while you still have the money. Okay. But if you are a beneficiary and you've not heard, then you're going to have to force the issue. You have to. Now, let's say you did get a copy of the terms of the trust and you get your 1/3. And you're thinking, okay, that's totally fine. And now it's been 9 months and you have no idea what's in the trust. You know that dad and mom had a house, don't know what it was worth. You're not sure what else they had. or maybe you do know, but you haven't heard anything going on. Like, how is the money being spent? Is the accounting moving forward? Is the house being sold? Is the house being rented? What's going on? Those are things you are entitled to know. What the California Probate Code allows is that if you make what is called a demand for accounting, then they have to provide the accounting within 60 days. It just has to be a reasonable request. You can't do it, you can do it like every 6 months. You can't do it every 3 months. So you basically, you contact, usually you do it through a guy like me, contact them and say, hey, I want an accounting of all the assets and the income and expenses of the trust, and I want it within 60 days. And then they're required to do that. If they don't do it within 60 days, it's a breach of their duty as a fiduciary, as a successor trustee. That might be grounds to kick them out of the trust and get them replaced with you if you're the next person in line. If they didn't deposit the will, if they didn't give you the notification, if they haven't given you the accounting when you requested it, those are all strikes against them that might make it so that a court would be willing to remove them or suspend them as trustee and let you do it if you're the next one in line, or let the next one in line, whoever that is, them do it instead. So as a beneficiary, you need to watch that. As a successor trustee, you need to do the right thing. You need to do what you're supposed to. Okay, so what is an accounting? When somebody's demanding an accounting, and that doesn't have to be, I demand an accounting. It could be, hey, I want to know what's going on. I'd like a complete financial picture of what's going on. That's a demand for an accounting. You don't have to say, I demand an accounting, although that works too. So with this accounting, it's going to be all the assets of the trust at the beginning of the accounting period, which is the date of death, right? That is assuming it's not an AB trust or something. So mom and dad die at the date of their death, then the trustee takes over, steps in, starts to do their job, hopefully, and they start accounting at that point. How much money was in the bank, how much money was in savings. Those things are sitting there because we know they existed at the date of death. And then what about other things? So you have the personal property, and there's a garage sale, and the garage sale brings in $1,000. That now goes in the accounting with a carry value of that $1,000 whenever it goes into the accounting. So we didn't know the value at the date of death, so now we do. So that can go to the accounting. So all those things, and then you find a bank account. You go, oh wow, dad had a bank account at Union Bank, so that money goes into the trust. Dad had a bank account at Wells Fargo, and he had one at Ally Bank, and he had one at all these different things. And a lot of older people have a lot of accounts, and they probably have financial advisors like me that are saying, Gary, why do you have so many accounts? I don't know. It was fun to open accounts online. So all those things go into the accounting, and everything I'm spending. So if you're the successor trustee and you're accounting, it's like, okay, I spent I had to hire an attorney, and that cost me this much. I had to hire an accountant, and that cost me this much. I opened a bank account and had to make this deposit. I spent this thing here. I drove, with the appraiser, and I spent time with the appraiser, and I had, I was there all day, and I had to get lunch. And so I'm charging lunch to the estate. So all those things get accounted for so that the beneficiaries can actually see what's going on. Okay. If you don't provide the accounting, then you're in breach of your duty as a fiduciary. So that makes it so then the beneficiary who wanted the accounting can say, my successor trustee's sister is a lousy trustee because I asked her on this date, here's the letter, here's the email, here's my phone call, here's my text, whatever. Here's when I requested the accounting, and it's been 4 months since then. And I reminded her in the meantime, and she's not giving me an accounting. I'm afraid she's hauling off for the money. And by the way, she has a new car. So those are the things where you can go to the court and say, I didn't get the trust. I didn't get a copy of the will. I didn't get an accounting. I'm not sure what's going on with the money. I want my successor trustee sister suspended, or I want her to account. So the court can do one or both of those things: require an accounting, suspend the trustee, put somebody else in place. That's what you risk if you don't do your job right. That's what you get if you, as a beneficiary, want to push that. So you just got to get your job done right. I'm going to keep talking about that a little bit after just a second. So coming up, I want to finish up my talk on how to be a successful trustee, how to do your accounting, coming up next year on the Word on Wealth, 855-500-TRUST.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
Gary, how do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and sometimes contesting parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST.
Tell a friend about this broadcast outreach, The Word on Well, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQlaw.com.
Live.
All right. We are talking about finishing up how to be a good successor trustee and specifically about accountings. We're running into this a lot lately. There are more and more law firms in San Diego specifically that are starting to pick up on the fact that they can go after successor trustees who are not doing a good job and recover money for the beneficiaries because the successor trustees not doing a good job. And here's the problem. As a successor trustee, because you're a fiduciary, the court, the probate court, yes, I know you have a trust, but yes, the probate court has jurisdiction to make decisions in the case. The probate court can surcharge a trustee. So if a trustee is not doing their job right, if they don't provide the accounting properly, they don't do a good job, if the trustee takes some assets that they're not entitled to, then the trustee can be surcharged, which could be some type of a fine or a penalty, but those surcharges, they can be expensive and they'll come out of that successor trustee's share. So if you're talking about, you get together as a family and you say, hey, it's just the three of us, let's not hire any lawyers. John, you're the successor trustee. Let's just all three of us just agree that we're going to split it down 1/3, 1/3, 1/3. Let's not worry about it. Don't be doing stuff like that because you're going to have, you got to do the tax returns. Brother John's going to figure out that it's not easy to be a successor trustee. Every time you have, a family get together or a phone call, they're going to be talking about the trust and business, and it just makes it really difficult. So don't agree with your siblings to decide to do it on the cheap and not do it right, because as the successor trustee, I don't care what your siblings agreed to. The law requires you to do the right job. And you might be able to argue later, well, I have right here, my brother agreed with me that I didn't have to notify the Department of Health Services. Well, it's the law. You're required to notify the Department of Health Services. It doesn't matter whether you agree, you're supposed to do it. So when the problem comes up and there's an issue later and the Department of Health Services comes back and says, hey, we have a claim against the estate for $8,500, you get to pay that as the successor trustee. I mean, yeah, you can go to your siblings and say, hey, you guys, we agreed to split all this, but then, what if there's a change of heart? What if there's a change of mind? What if your brother spent all the money already? Whatever. But, and even if the beneficiaries are saying, well, you know what? You don't have to give us notification. We're all friends here. We're family. We love each other. You don't have to do this official notification. You don't have to notify the creditors. Let's not worry about it. Dad didn't have any creditors. That's where you run into danger zone, danger, because when we are talking about notifying creditors and doing an accounting and all that, we're talking about the requirements of the law. The notifying creditors is going to be, what if there is a creditor you don't know about? What if there's a slip and fall? What if somebody got injured on the property and you don't know about it? They've got 2 years to sue you. You want to keep the case open for 2 years to see if they're going to sue you? Why don't you do notification? A general notification to, unknown creditors. If you have a claim against this estate, you got, 120 days to make a claim or forever barred. If they make a claim later, you just whip out that little article and you say, oh, look, I sent you notice. There's a general notification in this newspaper here that says you had 120 days to make a claim. Sorry, you're out of luck. So those are some of the things I want to keep track of because I don't want to risk it. I don't want to do it wrong. I don't want to have something just hanging out there later where you're kind of like going, oh my gosh, I wish this 2-year statute of limitations would pass so I can relax. I mean, with the accounting, you just want to do it as you go. You want to put the paperwork together. It may not have to be a formal accounting where you hire a financial fiduciary to do a perfect job, but you need an accounting. I mean, one way to do it is like through QuickBooks or Quicken, and you just keep track of all of your expenses, and that way your siblings can review that. At the end of the deal, the end of the accounting, end of your term, your tenure as the successor trustee, I want the beneficiaries to have reviewed your documentation, your accounting, whether that's going to be just a printout of your Quicken checkbook or, if they're okay with that, and that they are okay. And they say, yes, I'm okay. I see what you did. I don't like all the numbers, but I can live with them. And then they sign an agreement saying they agree that you did a fine job. Not perfect, but you did a good job. You did it well enough, and they're happy with the amount of money they got. That's what we want. That's our ultimate goal. With you as a successor trustee, you want all of your beneficiaries to sign off saying that you did okay and they're not going to sue you later. Now, if you're a beneficiary, on the flip side of that, you definitely want a beneficiary agreement because it requires that the successor trustee, your sister that's doing the successor trustee thing, that she accounts for all of her spending. So if she's going to go in, if there's a bunch of spending on there that, trip to Hawaii, why'd you do that? Well, because I needed a break. I'm really stressed out over this trust accounting. I'm stressed out over Dad's doing this trust work. And so I decided to go to Hawaii as the trustee for a break, and I'm charging the trust. It's like, really, not that people actually do that, because I haven't seen Hawaii. I've seen a lot of other things, but that's, you just got to keep everybody honest. That's what the trust accounting is for. That's what the beneficiary agreement is for. What I do with a lot of people is they'll have already got it started. They'll have found the bank accounts and they're starting to get started. And then I say, did you get a tax ID number for the trust? Well, no. Dad did the trust so that we could avoid probate. I said, no, it has nothing to do with probate. It has to do with the fact that your dad's gone. You can't use his social security number anymore. And you have to now use a tax ID number that you get from the IRS. Oh, I didn't know that. Dad passed away 6 months ago and we've just been using his social security number. Let's not do that because that's not legal. His social security number stops working when he does. And you need to do a tax trust ID number that you get from the IRS. And then that creates what's called the administrative trust. The administrative trust is the date of death until the distribution is final. That is what gets accounted for. Okay. So everything's under dad and mom's social security number. Mom dies, dad dies. Then we get a tax ID number and all the money goes into that tax ID number. So that means you go to the bank and the account is, it's a trust account, right? You go to, let's just say Navy Fed. It's easy. So you go to Navy, let's use Chase. So you go to Chase Bank and dad has an account in the name of the trust and you're the trustee. So now you say, hey, dad passed and I want to get going with the distribution. Then if they know what they're doing, because you get the right person, and they say, okay, do you have the death certificate? Yep, I got it right here. Do you have the trust? And how about your ID? Right here. So you got it all. All right, let's open up the account in the name of the trust. You got your tax ID number, right? Yes, here's my new tax ID number. Here's my proof of who I am. Here's the trust saying I am the trustee. And here's my dad's death certificate. And they open up a new account in the name of the trust. That is the administrative trust bank account. That's where you put all the money. Everything goes out of dad's name. Everything goes out of the trust, the original trust name. Now it's an irrevocable trust. It's called the same thing, the 1985 trust, but the money is going out of the trust bank accounts at the date of death to this new account. You sell an asset, you put it in that new account. You sell the car, you put it in that new account. You have an investment account, you want to close it, you move it into that new account. So that this one new account, this is the easy way, guys. That's where all the accounting is. So if you're doing an accounting of that because you have QuickBooks or Quicken or something, or you do a ledger, when your siblings want to know what's going on, you can just send them all the bank statements and send them your Quicken book. And that shows exactly what's going on, how much money's income. So always do everything that way as a checkbook. Don't do things cash, don't get out petty cash, whatever, just do checkbook. You write a check or you use a debit card, or in that way you're spending the money and it's going to all show up on those bank statements. That's what I recommend. That way, when you do the accounting, it's easier. You just turn it over if they want it. If your siblings want an official accounting, I get it. That's understandable. We do that a lot. We get an official accounting. We provide all that to our financial fiduciary, and they put together every penny, every transaction to make sure it balances. It's super awesome.
Commence.
But you've got to do in accounting. You have to keep track of your expenses. It's not easy, but I would say every time something comes in, put it in a new folder and say, okay, this is the such and such a bank account. Here's the savings account. Here's the rental property. Here's the sale of the house. Here's the personal property. And you keep it in folds. You just keep it. That way, when it's time to do the accounting, put everything together, it's all in one place. It's not a big mess. Messes are difficult. They're not impossible, but they're difficult. So accounting, important. Account to your siblings, the other beneficiaries, important. Sometimes you have a charity and they get some of the money. Well, they're waiting for their money. And if they get a percentage, they got to wait till the end, just like you. If they're getting a dollar amount, then they get it within a year. So just remember that too on specific distributions where it's a dollar amount or a specific thing that is actually itemized in the trust that is to be distributed within a year. Okay. If it's beyond a year, technically that's not reasonable.
Wait a minute.
Okay. So don't do that. Specific distributions within a year. All right. I hope you've learned a lot today. Trust accountings are important. You've got to keep track of everything. It is not your money. And that's the thing that I'm just finding that successor trustees don't understand. It is not your money. Maybe it's in your name, but it's in your name as the successor trustee. It is not in your name directly. So if it says Johnny Brown, trustee, that doesn't mean it's your money. That means you're managing it as the trustee and you have a fiduciary duty to get it right. Call me and let's work through this. 855-500-TRUST. Call me before you get in trouble. Call me before you don't do it right. Call me before your siblings start to get upset about it. 855-500-TRUST. If you want to motivate or inspire your trustee to do a good job, to do it right, to stop messing up. 855-500-TRUST. Let's help you get your inheritance. Let's do a trust for you. If you don't have one, get one. 855-500-TRUST. Talk to you tomorrow with Ken Pecos, and talk to you tonight in the Andrea K Show at 7. Bye, everybody.
Tell a friend about the Word on Wealth, featured since 1995, with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily represent the views of Salem Media Group or its...
Just so you know, tonight there's a guest host for Andrea, but we're still doing it. I've already told him what you talk about and all that. So
Okay, so I should still call in then for sure.